All right, welcome to another episode of Powerhouse Conversations. I'm your host, Fred Underwood, and we are back with another episode. Powerhouse Conversation has powerful discussions around digital transformation of sports brands. We bring on professionals within the sports industry to have conversations about how you can help grow your brand. Today we have a special episode, and we're gonna have a special episode dealing with the legal aspect. I know we haven't had one yet, so I've been really wanting to have one to bring someone on to talk about some of the things that aren't being talked about in these NIL conversations, and is definitely needed. So we have Kassandra here today, the Esquire coach. Uh, thank you for coming on, and how's your day going?
Hi, thank you for having me. I'm excited to be here today to have this conversation. I'm in a sports and entertainment attorney in the Washington D.C. metro area. I work with artists, athletes, and entertainers on protecting their brand. One thing that we'll get into, I specifically work with them on how to apply for federal trademark registration. So we'll get into how that applies in the NIL context.
Yeah.
And
Well, thanks again for coming on. So let's start with how did you get into the NIL space? Like what made you want to go into that?
So when I was in law school, I wrote a paper on advocating for college athletes, right? Specifically that they be allowed to finally, I guess, quote, get paid, right? As
Hmm.
everybody knows, pay for play,
Right,
but it's much bigger than that. You
right.
know, it's advocating for them to just be able to have a more equitable piece of the pie.
Hmm.
College sports is $1 billion industry, while athletes were, relegated to a scholarship, and while that is valuable, it still did not quite match up with the value that they were providing to everybody else. Excuse me. When coaches have $1 million salaries and we have $1 billion television broadcasting deals, to limit athletes to a scholarship was, in my view, a little unfair.
Right.
Again, not to say that the scholarships aren't valuable because they are, but to say that they can't even at least make money off of their own name and face is really was really just unfair. So I wrote that paper and I just stayed in the space. And I got an opportunity to start doing sports writing, and my focus was on the business of college sports and name, image, and likeness. So this is all around like 2018, where it wasn't as popular as it is now, right?
Right, right.
But the topic was starting to get some steam, and I was always on the player advocacy side. In the meantime, the Alston case happened, so I wrote about that, which isn't NIL specific, but it still was a case that broadened the rights of college athletes and what they're able to receive from the schools. And so initially, a lot of my work was just writing on the topic
Okay.
and advocating for college athletes' rights.
Okay. And so tell me about your law office. Is that specifically athletes? I know you mentioned entertainers, but how?
Yeah, so creatives,
Okay.
ent- entertainers, and people who fall into that space. So basically, I assist my clients with federal trademark registrations, copyright registrations, and help with some contract drafting and just pointing them in the right direction for how to run their businesses.
Gotcha. So that leads me to so for people who don't know, what is IP? What is intellectual property, and how would you explain it to an athlete?
So intellectual property is kind of just like it sounds, right? It's like the property that comes from your mind. So the best way to explain it is to give an example, right? We all know Nike. When we see that swoosh, we know that that's a Nike product. We know the brand. So that is a trademark, right? So when we see that swoosh, we automatically know, okay, this is a Nike product. Right now, a lot of the things that we're using, microphone, your iPhone, all of those things contain patents. That's another type of intellectual property.
Hmm.
And then another type, which we won't really get into too much, is called a trade secret. And the most common example of that is Coca-Cola formula. And then lastly, we have copyright, right? So we have copyright in music, books, film. This podcast episode, you have copyright protection in that. While these are all forms of intellectual property, the way that you protect them, has varying degrees. So the steps that you need to take to ensure that you are protecting your intellectual property.
Gotcha. No, that's perfect. That's perfect. And I think that that's something that the athletes, especially these young athletes, they need to learn about. They need to know about because their intellectual property needs to be protected. And I think there's a lot of, companies and businesses that are coming around and they're taking advantage of athletes because they don't understand, what they need to protect. So they're getting in there, they're signing these deals and they're not really understanding, what they're signing away.
Absolutely. I think the two most applicable for athletes at this point would be trademark and copyright.
Yep.
Um, so trademark is applicable to athletes. One, because say you have a nickname, something that you go by.
Mm-hmm.
For I'm just throw it back a little bit, right, and go back to the days when Johnny Manziel was playing and he had Johnny Football,
Yeah.
right? So let's say that he was in this time where you could do NIL deals. Like that's something that he may want to apply for federal protection for because he can build a brand around that, start selling merchandise and things of that nature. So he would be the perfect candidate to apply for federal trademark protection
Right.
for that. Then if he gets a logo made,
Mm-hmm.
you can get federal trademark protection for that, like we was talking about the Nike swoosh.
Mm-hmm.
But then the other realm of intellectual property that I think is applicable to college athletes is copyright. So let's
Mm-hmm.
go back to the logo, right? So there's two types of protection you can get for your logo. You have copyright protection and trademark protection. So I have to kind of briefly explain the difference in obtaining copyright protection and trademark protection. So when you are seeking trademark protection, you have to apply with the United States Patent and Trademark Office and go through the whole application process. And your application has to be approved before you are given federal trademark protection. And But for copyright, as soon as a work is created, right, what in the legal term is like an original work of authorship, right, that's fixed in the tangible medium of expression. Okay, what does that mean? As soon as a work is created, so we're going to keep it on logos. As soon as a logo artist creates a logo and puts it on paper where another person can see it, the artist has copyright protection in that. They don't have to register with the U.S. Copyright Office in order to have protection. They get it as soon as it is created. Now,
Mm-hmm.
notice that I said that the artist has copyright protection.
Yeah.
So if you, the athlete, are not the artist who drew
Right.
it,
Right.
you do not own the copyright. You have to take other steps in order to own the copyright. And those include that you have to either have it made with a copyright assignment where the artist who made the logo for you will assign all copyright rights over to you as an artist, or you get the artist to do it as a work made for hire, in which case the artist will have quote me your employee, meaning that because they're your employee, then you will have always owned the copyright protection. But those two things, however you decide to do it, needs to be in writing.
Yeah,
Those
I was just about
documents
to
need to
say,
be in
so
writing.
like you need to have a contract, like
Yes.
anytime that you're getting any of this work done, as an athlete, you need to have some type of contract, that protects you, that you can keep that art that you that you got done, logo, whatever it may be. You need to make sure that you're getting the proper paperwork that protects you.
Yeah.
Yeah, because I could see a world where all these athletes are, they're in college now and they get something done, and then they wait till they get to the NFL, the NBA, or something like that, and then the artist comes back and is like, oh, that I own that, so I need you to pay me.
It's kind of, if you think about Kawhi Leonard with the
Hmm.
claw, right?
Hmm.
He thought that he owned the claw, but Nike ended up saying like, no, we own the claw, and Nike won. They ended up owning it. So that's definitely something that you need to look out for in your contracts. Whether even if your school is assisting you with making that logo,
All right,
you need to make sure, however that happens, whoever assists you, that you are the owner of it.
gotcha. So when Kawhi left Nike to go to New Balance, right?
I think it was New Balance, yeah.
Yeah, and that's when that happened. He thought
Yeah,
he
that's
he tried to take that logo over to them, and Nike owned it.
yeah,
Oh yeah,
that's what
so
ended up doing.
that's definitely something that people need to watch out for sure, for sure. So what are some of the other examples of how NIL athletes can trademark, copyright? Because I know a lot of these kids are, starting podcasts, YouTube channels, things of that nature. What are some of the other opportunities for them that are out there, but they need to make sure that they're trademarking or copywriting?
So yeah, if you do have a podcast or some type of medium like this, you like I said, once the episode is created, let's just keep it on podcast. You do have copyright protection, and I
Hmm.
said that you don't have to necessarily apply with the copyright office in order to have copyright protection, but there are benefits to applying with the copyright office. Let's say you find yourself in a copyright infringement situation where you need to bring a case. So the sooner you register with the copyright office, the more damages you may be entitled to if you should win. And then, also by registering, you're putting people on notice that you are the owner of this copyrighted material. So there are other benefits to registering as well. So, it's definitely, something that you should consider doing.
Gotcha.
On
So,
the
so as a
Go ahead.
podcast, owner or whatever, anytime you record the podcast, you still you do you have to file that, or do you own it because you recorded that podcast?
So there are benefits to filing it. But like I
Mm-hmm.
said, copyright protection attaches as soon as the work is created.
Mm-hmm.
And yeah.
Okay. Okay.
But unlike trademark protection, that does not attach as soon as you create your business name.
Right.
So there are steps that you would even want to take. So let's just keep going with Nike. So once you come up with the brand Nike, like, oh, I like this name. I want to use this
Mm-hmm.
for selling t-shirts, right? So what you're gonna want to do before you do that is something called a trademark search, or
Right.
have an attorney who works in intellectual property do this for you, and
Mm-hmm.
that's gonna um, you're going to search not only the USPTO's website, but you're going to
Mm-hmm.
want to do just a Google search to see
Mm-hmm.
who may be using it on Google, social
Mm-hmm.
media, um, and in different in all of the state databases. You're going to want to make sure you check everything, because the last thing that you want to do is spend time building a brand around
Mm-hmm.
something that isn't available.
Right.
So the first thing you want to do really is make sure that your name is available.
Right.
So if you do the search and you find out that your name is available, if you are already using the name that you have, then you can go ahead and apply with the USPTO for what's called a use application. Why
Okay.
does that matter? In order to be given federal trademark protection, you have to use the trademark in interstate commerce. That basically means that you have to use it across state lines.
Gotcha.
But if you are, have a name of something and you haven't already begun to use it, Paige Buchers, I think the site's her last name. She played for Connecticut.
Yep. Yep.
She did this right when NIL started. She applied for, I can't remember the name of the trademark that she was applying for, but I remember she did what's called an intent to use application
Mm-hmm.
for the trademark that she wanted, because she
Mm-hmm.
had not yet started using it, but she didn't want somebody else to get it.
Right.
So she filed what's called an intent to use application, and basically that allows you to kind of put a placeholder on the trademark that you want and give you time to start using it. Why
Gotcha.
is that important? Right, let's remember the Redskins at the time when they were changing their name, and this guy like went and filed trademark applications for all the possible names,
Mm-hmm.
which made it kind of hard for them to find a name. Then they ended up spending some time as a Washington football team. So
Right.
that's the benefit of filing an intent to use application, is it gives you time to get started.
Gotcha. I want to dive a little deeper into the steps to getting a trademark. I want to for people that are watching and listening, what is the cost and the time frame associated with getting that accomplished?
So the cost, right off the bat, from even if you don't hire an attorney, right, the United States Patent and Trademark Office fee goes from, I think it's $275 to $375, depending on what type of application you use. So, and that's per class of goods and services. So the USPTO divide things up into class of goods and services. So
Okay.
if you are selling T-shirts, right,
Mm-hmm.
that's one class of goods and services.
Mm-hmm.
Then if you are, well, that's one class of goods, right?
Mm-hmm.
Let's say that you're providing some kind of educational service, then that's a
Right.
service. So you will have that fee twice because you are applying in two
Because
separate.
you need to make sure that you are having that trademark for two or whatever, how many ever it is, separate things. Because if you go and only apply for goods, but somebody else is doing consulting and they want to use the same name, they can trademark that under that same name. Is that correct?
Right, right.
Okay.
Because so when the USPTO looks at applications, they look to see if there's a likelihood of confusion. So because basically trademarks kind of protect the consumer because it's the consumer being able to look at what they're buying and know that that's that company's product. Like you know when you see a Nike check that that's that company's product.
Gotcha.
You know when you see three lines that that's Adidas. So that's that's the aim of trademark is the consumer being able to know what they're getting. So um, you have to make sure that you apply for it and get the protection for each category of use that applies to your business.
Gotcha. And so, okay, so you pay that for the search and apply for each
No, that's just the fee for the USPTO.
for
Now,
the
if you're doing
yeah.
a search, like
Got
you can do like a Google search. You can go to the state databases, and what you would do is like where you go to say you want to file for a LLC in a certain state.
hmm
That's what I'm talking about. I know for DC, it's like the DCRA
hmm
um website, and you will put in the business name that you want, and you'll see if anything comes up, and you will want to do this for every state, including the District of Columbia. And then another place, a good place to look is social media
hmm
sites, and then again checking the USPTO website too. But the reason why you can't just check the USPTO is because everybody doesn't apply for federal trademark, but
Gotcha.
that doesn't mean that they aren't already using the
All right.
trademark. And just because they haven't applied doesn't mean that they, couldn't come after your application, because if they started using it first and then they decide to go and apply, they see you using it, they can challenge it and say like, hey, we were using this first.
All
So,
right.
the search process is pretty intricate, which is why it is it may be beneficial to hire an attorney for you who can do that comprehensive search for you. And there are companies that do comprehensive searches, and then they have their own fees as well. Then if you do hire an attorney, the attorney has their fee as well.
Gotcha.
Unless though you are able to find somebody who would do that service for you pro bono. Um, and then that's I know we kind of talked about this before we started the show. But another thing that I would mention is that there were some schools who their law school clinics was
Mhm.
providing these type of services, right?
Yep.
And that is okay. And according to the new clarifications, at least as it applies to Division One, because it came from the Division One board, schools can provide those services as long as they are available to other students as well. So
Gotcha.
whether or not if your school provides a service, that's something that you'll have to look into.
Gotcha. So basically, they can't just provide it to the athletic department. They have to provide it to the entire campus.
As of last week, it has to be
That that
open to
that's definitely
other students as well.
yeah, that's a something a decision that schools have to make, because I know they
Right,
probably were like, okay, yeah, we'll do it for the athletic department, but now that they have to open up to school wide, like that's kind of um something that they probably have to think about.
right.
Okay. No, that's definitely good information. And oh, the timeline on the process. What's the timeline?
Oh, so the USPTO is rather backed up. So just to kind of, it's taken over a year really to
Mhm.
get movement. Like I filed for a application last October, and I'm
Mhm.
just now getting some movement on it. Like as of really October, it took about a year before I heard
Gotcha.
back from the USPTO on it.
Gotcha.
The
And
copyright registration isn't taking as long. You're looking at maybe like three months
okay.
before you hear back from them.
Okay. And you said there is I think you said Page used this intent to file.
Oh yeah, it's called an intent to use application. So if you have XYZ name, but you're not yet selling your T-shirts, but you want to keep the name XYZ, you
Uh
still do your due diligence with the trademark search and all and everything, because like I said, the last thing you want to do is spend time, money, and resources around building a brand that's not available,
mhm.
because the USPTO does not issue refunds. So
Right,
you
right,
want to make sure that what you're as as much as you can make sure that it's available. And the intent to use application allows you to kind of put a placeholder on it until you actually start using it. But you do have to verify that you do have what they call a bona fide intention to actually use the trademark. you can't just squat on it and have no intention in using it. Like you have to have an intention to use this trademark for this class of goods or services.
Gotcha. That makes sense. That makes sense. Okay. So changing pace. I know one of the things that is going around is the high school NILs. Like I know certain states are having different conversations about whether high school athletes can utilize NIL. What's the parameters about that? What can you tell us about that?
So it's state specific. I know it was at least 18 states, I
Okay.
think, and, including the District of Columbia that have modified their rules to allow high school athletes to engage in NIL activities. And really, you're seeing the state's high school athletic associations is the entity that are modifying their rules. I think eventually we'll see it everywhere, because it'll be very much a domino effect, kind of like with the college rights, right? Where
Mhm.
no state wanted to be left behind, and
Right.
everybody wants to be able to have that competitive advantage. So
Right.
I think eventually we will see it across the country.
Yep. Because I would imagine that that's going to attract high school talent, and that's something they're going to want to make sure that they're a part of. Like you said, you don't want to be the state that isn't. If everybody else is have allowing kids to capitalize off that, that's going to be parents are going to look at that and they're going to be like, okay, well, why not just move to this state? Because at this point, a lot of these high school athletes, they're looking at it from a business standpoint at that age. It's a business decision on what high school you go to. So I think that's definitely
I mean, absolutely. Like even before, we had this many states that amend their rules. Just look at Mikey Williams, who attended a prep school. So
hmm
because he was in a prep school, he wasn't subject to. I think at the time it was North Carolina. He wasn't subject to their ban on high school athletes engaging in NIL deals. So he was able to get that deal with a Puma, and
okay. So
so
it's
that's how he
only
was able to do that.
the only state schools can be governed by those rules.
So
Probably.
the prep school that he was attending, because he was at a prep school, he wasn't subject to North Carolina's
That's
state
interesting.
high school athletic association rules.
Okay. Okay. No, that's interesting. Definitely something to think about. So I do want to, because there's a lot of backlash and a lot of different opinions on NIL in general. What's your thoughts on the impact that it's having, and what are your thoughts?
Like I said, I advocated for this for athletes for years before it ever happened, so I am perfectly fine with it. I think that it's long overdue
hmm
that the athletes are able to finally receive more of the benefits that their labor bestows to so many others. I am an advocate for the financial literacy courses
hmm
and any kind of education course that is available to athletes. I think that they do need more resources,
hmm
more platforms like this where they can come in and learn a little bit about what they're up against now, because it is more of a business now, and they have to be more savvy,
Right.
because just like with anything, you're gonna have some people who may be a bad actor, but generally overall, I think it's been a good thing.
Gotcha. I agree. I agree. And so, what do you say to the people that have that backlash? Like, oh, it's going to mess up locker rooms. Oh, it's going to mess up the landscape of college football and all these other things. What's your thoughts on that?
Um, I think it's just people just trying to nitpick and find an issue with it. I
hmm
mean, is there a potential that it could cause a potential rift in the locker room? Maybe, but also maybe not. We've seen a lot of um deals that's been offered to an offensive line or offered to the entire team, and even individual players sharing
hmm
their stuff with their team
Right.
members, which
Right.
I think has the opposite effect, right? It
Right.
builds more camaraderie because
Right.
now you want to do well,
Right.
for
Right.
more than one reason.
Right.
So
Yeah, we saw CJ Stroud give stuff to his entire team. I think Bryce Young did the same thing. Like it's definitely something that when the especially if a QB is getting it, like they're gonna spread the love to the rest of the team because like you said, build it's a way to build team camaraderie. So I think that's definitely something to look at. So which that leads me to licensing. Like tell me about group licensing and how that works.
So group group licensing, if we want the college football game, we really need group licensing. So that's how we get Madden, right? So
Yep.
the NFL Players Association has an agreement with all the players through their group licensing, where they all say, okay, we'll give our name, image, and likeness to be a part of this game, and then everybody gets a certain part, and they just all agree to it.
Mm-hmm.
So but that's because the NFL is just so many teams, then you have the Players Association, and you're able to do that. How
Mm-hmm.
do you accomplish something like that on the big college scale?
Right.
Where you have Division 1, Division 2, Division 3, and all of these different schools or different conferences, and so it's a little harder in the context of the football game,
Mm-hmm.
but it is a concept that I think can help get us back um, that way for those who want the game to come back.
Yep. So
And
how were
I
they? Okay, go ahead.
go ahead.
I was just going to say how. So how were they able to do it previously? Because it was just because they didn't have any control over their name, image, and likeness, or
Right. So that's really that's really what started all of this. So you
okay.
go back to 2009 with the Ed O'Bannon case.
Mm-hmm.
Um, and Ed O'Bannon, former UCLA basketball player, team played in the 90s. They won the NCAA championship. He saw himself as an avatar on the video game.
Mm-hmm.
And even though it didn't have his name, did not say Ed O'Bannon, the
Mm-hmm.
player wore his number, the player was left-handed, the player was bald just like he was. Like
Mm-hmm.
everything about this player was clearly O'Bannon.
Right.
And when he thought about the fact that the NCAA and EA Sports sells this game for $60 a piece,
Right.
you know, to everybody about it, and he gets nothing.
Right.
And so, he sued the NCAA and EA Sports. And EA Sports settled. They settled. They were willing to keep making the game, but the NCAA did not settle. They took it all away and were not willing to make the game because, they were not willing to allow players to make money off
Right.
of their name, image, and likeness. So
Right.
that's how the game ended. And
Gotcha. Well, shout out Ed O'Bannon. Shout out
yeah,
Ed. Shout out Ed O'Bannon. Let's see. But no, that's definitely some history on how that came about, and making sure that he's able to just start this process, because I know everybody wants college football back, March Madness. I remember playing that as a kid, so I think that's definitely something that was important to start that process, because they should have been getting paid, right? Because just to be able to play a game, and all you did was just keep their names off of it. But like you just said, their likeness and their image is being utilized, and you're selling millions of copies of the game. That's just totally unfair. So I definitely hope that is something that changes and gets handled soon.
right.
And so next, or lastly, I want to make sure I talk about contracts. I mentioned it a little earlier about these players that are signing contracts, and having to maneuver some of that. Are how do what you have in the law office, and other people, how do they make sure that they are utilizing their best their advantage? Like, do they just reach out to a law office like yourself? Like, do they have a lawyer on retainer? What's the best way to go about maneuvering in this NIL space?
Yeah, you can reach out to a lawyer. Like me, or like I talked about earlier, the schools with the clinics,
Mm-hmm.
as long as now we know, as long as they're providing that opportunity to other students, your school may have that resource available. um you know Maybe even through, if you have a agent, it can try to help you connect you with someone who can
Mm-hmm.
look at your contract for you. And that's contract review is very important. And when I talk about contracts in this space, I always bring up, one thing that I think everybody should look out for is you don't want to do anything in perpetuity. In perpetuity means forever. You don't want to give any rights away in perpetuity. And another another concept that you need to understand is just like we talked about group licensing, but
Mm-hmm.
there's more to licensing. So say you have that XYZ brand that you built and someone wants to use it. Well, another type of contract for you to be aware of is like a license contract, where you'll give somebody um permission to use your brand for what they're trying to use it for, and then that's a way that you can make money. And then one thing to watch out for with licensing is that you want to look for the words exclusive versus non-exclusive,
Mm-hmm.
right? You don't want to give anybody an exclusive right to do
Right.
anything because you want to be able to give it to other people. So you're going to
Yeah.
want to make sure that it says non-exclusive. And then another thing that brings me back to trademarks and licensing and how this all goes together is you have to be careful with your school trademarks.
Mm.
Most schools are not just allowing you to freely use their trademarks, if they are at all. Some state laws, in fact, actually um, prohibit college athletes from using their school trademarks in their NIL activities because the schools license out that, and that's one way that they make money. So
Right.
you're going to want to look at that before you use your school trademarks or colors or anything anyway.
Gotcha. So perpetuity, make sure make sure anybody's listening, do not give out anything in perpetuity, and do not give up your exclusivity as well, because you don't want to be signing any contracts that are taking any of those rights away. Are there any other gotchas that you think that people should be aware of
Um,
with dealing with contracts?
Yeah, I was just for one thing, make sure you like read your contract. Read the entire contract. And if you have questions, don't be afraid to ask,
Yeah.
and if they don't want to answer, then that's probably not somebody that you should be
Right.
doing business with,
Right. No, and I definitely think that's something that's key. I know you see a lot of these platforms that are popping up that are bringing these the businesses and they're making the platform where the athletes can work with the businesses. I think that's one thing that they definitely need to be able to somehow monitor. But the people that are putting these contracts in front of these athletes, I don't know if there's any type of liability, or do they give up? Are they signing away their liability? They're just connecting the athletes. Are they doing any due diligence on these NIL marketplaces when they're connecting these athletes to these brands? So that's something that's very interesting to me.
yeah, it's a developing space, so we're kind of just seeing as it goes, but definitely look at any contract, whether it's from a marketplace or from a collective or whatever. Make sure you review it and make sure that it's favorable to you.
Gotcha. Yeah, and as we wrap up, I definitely want to say sometimes, because I know you have a lot of resources, you have a lot of things that you offer. Can you talk about some of those things that you have, services that you have?
Yes, I run a website, www.theesquirecoach.com, which is a resource for any current or prospective college athlete or anybody working in that space. I keep up to date with the schools that allow, I mean, the states that allow high school NIL rights. Try to keep up to date with the collectives and the different programs that schools have to assist each athlete with their NIL. And I also have a social media audit template that you can download for free, and that gives you access to my newsletter. So the social media audit allows you to kind of take an audit of your social media and see how you can better use it, because social media is a big player in this new
Right.
NIL space. And then that also gives you access to my newsletter where I keep you up to date with the latest happenings in NIL and give you tips where I explain, things about intellectual property over contracts a little bit,
Yeah, well,
once
and we'll definitely have we have those links in the show notes and things of that nature. So we'll have those available for you all.
yeah.
Yep. So I'll let you close us out and leave us with any final advice to any NIL athletes that are out there.
Yeah, my final advice would just be to get as much education and information as you can. If you don't understand something, don't be afraid to ask. Ask your school, ask their compliance departments, and just do a Google search. Look at and for those who may not have chosen a school yet, maybe you're a prospective college athlete. Do your research and see what programs the schools that you're looking at offer to help you navigate NIL.
Gotcha. Well, Cassandra, I really appreciate you coming on. This was very insightful and informational. I learned a lot, so I definitely think that our listeners are going to learn a lot from you. Make sure that make sure you follow her on all social media platforms. And like I said, all her information will be in the show notes. And thank you again.
Thank you. Thank you for having me.
All right, so see y'all next week, and we'll follow us on Dream Big Sports, Dream Big Fred at on Instagram and Twitter, and we'll see y'all next week. Thanks.